this particular convention process, there is no restriction. Any type of disputes can be referred to mediation, and most interestingly, the smallest personal dispute to the largest long-term investment or infrastructure project disputes can be referred to mediation. And this convention is going to facilitate the three organs of the state, namely the executive, legislature, judiciary, all would go abrupt, perfectly walking with shoulder to shoulder to make mediation a proper way forward. This is very interesting development which is happening or which is going to happen in Bangladesh when the Bangladesh jurisdiction is going to adopt this particular convention. Adoption of this convention and ratification of this convention is going to facilitate, is going to clearly facilitate the Pandora box to be open, wherein any dispute, all dispute, what might be the nature of the disputes, even political dispute. I was happy to hear from Ms. Tanushree Roy yesterday. She was speaking about political disputes. And interestingly, this Qatar blockade was facilitated by a mediation. The removal of that blockade was facilitated by the mediation by Kuwait. Likewise, politically also, this mediation is going to do wonders, and that wonders have to be ultimately enjoyed. Ultimately, that benefit has to go to the common citizen. That is very important. As people in legal fraternity, as honorable judges, all of us are going to facilitate acceptance of this, the principle what has been laid down in this model law in total or in spirit, so that the mediation is going to resolve all type of disputes. I'm very happy here at this moment to say this model law on the international commercial mediation, which deals about what is mediation, then how to commence this mediation process, then how many mediators have to be appointed, further how this mediation has to be conducted, how communication can happen in that mediation process, what are the things as an information to be discussed by the mediators as the parties, what is the principle of confidentiality, to what extent the admissibility of evidence, particularly this mediation process, whether it can be considered as a evidence in other proceedings, to what extent this mediator can act as an arbitrator or refer this matter to arbitration or the court proceedings, and ultimately how the mediation proceedings has to be concluded or terminated. All the things has been covered in the model law, and when we come into the Singapore Convention, it categorically gives us option how we can settle and enforce that settlement agreement. That is very important. The settlement agreement and the legal effect of settlement agreement is the ultimatum of any disputes. As a matter of interest to all of you, I have, I think, another 5 minutes, 5 to 10 minutes to conclude. Very interestingly, this particular Singapore Convention has given a legal effect of settlement agreement. The first issue in the compromise package is whether the concept of recognition as well as enforcement should be included as the New York Convention. If you happen to see, or in the later time, if you have a time to see into the New York Convention of 1958, which is called the Convention for Enforcement of Foreign Arbitral Award. This convention, that is the Singapore Convention, also is considered to be at par. That is the reason why the first issue is that the compromise package was whether the concept of recognition as well as enforcement should be included as in the New York Convention. This may appear to be a question of terminology, similar to the differences like how we happen to look upon conciliation and mediation. However, this recognition differs widely in substance, as well as it forms across the jurisdiction. By the way, why it is included was ultimately avoided in favor of more creative functional approach. The very interesting thing about this settlement agreement is that it is favoring the more creative functional approach. And this functional approach incorporates the desired legal effect of both concepts, that is, the settlement agreement can be enforced or invoked, as well as provide a shield which invokes as a defense against a claim or against enforcement. In both ways, if there is a way for enforcement, there should be a way for defending that enforcement also. That has been given clear mandate this convention. Further looking into this settlement agreement concludes in the course of judicial or arbitral proceedings. That is the second issue. Second issue seems to have been the least controversial when the discussions were going on. This was considered to be a least controversial. Why? Because if a settlement is there, both the parties are agreeing. When it is having the status of enforceability or it can be recognized, there is a question of the other process. Still, it is considered to be an agreement, an enforceable agreement or a recognized agreement, which is eligible for enforcement. But if one party who has entered into such settlement or agreed for that settlement agreement is not keen or who claims that that settlement was out of some force of coercion, there is some external factors which made or forced this one of the party to enter into the settlement agreement, there should be further course of judicial proceedings. That option also has been given under the Singapore Convention. Third, considering the third issue, which reflects a compromise on a more controversial question, very important question, in some circumstances, parties opt into the convention with some reservation. If you look on carefully, Article 8, I think, you can refer it to the Singapore Convention, Article 8, which gives an option for reservation. Some countries, like a country like Belarus and even Iran also is now ratified, they have opted with some reservations on that particular convention while accepting the convention and enforcing or adopting in their national laws. That reservation also is permitted. That we call it as declaration by states requiring parties to opt in and out of the convention. Finally, the impact of the mediation and the mediator's conduct on enforcement. That also is considered in this Singapore Convention. There are various grounds for refusing to grant relief relating to the mediator's misconduct. Mediator can also play an unacceptable role in that process. He might just be biased. We are expecting a mediator to be really neutral, really independent, really unbiased, but still, if some mediators come under the category of doing some misconduct, there should be some relief. That relief also is being facilitated by the Singapore Convention. All these paves a good opportunity for any country, not only Bangladesh should be inclined to sign and ratify this convention. Every country beyond this 53 who have already signed have to opt for this particular very interesting convention, and we need to have a law on mediation. Now, if I have a time, another 5 minutes, I'll just narrate some clear benefits alone out of this convention. First benefit, the mediation obviously, which is a rising in popularity as a means of resolving cross-border commercial disputes, um, is complemented, and it is complementing other modes of dispute resolution. In
Sir,
that way, yes.
you have 10 more minutes of your allocated time.
Okay, thank you. This mediation complements other modes of dispute resolution, and it can be used in conjunction with litigation or arbitration. In that way, that is the first benefit of this convention. Second, however, if you look into the growth, which has been hindered by long-standing obstacle the parties are facing in ensuring the other party, whether he is complying with the mediated settlement agreement, all these are still going on. But when it comes to a mediated settlement agreement, which is a creation of this convention, unlike other court judgments or an arbitral award, even though it is only binding contractual, it can be directly enforceable in the courts. This is another benefit of this convention. Earlier, before bringing in of this convention, we had the concept of conciliation. We did have mediation also. We had matters referred by courts. There is a court annex mediation under section 89 or 89A. All these being referred to mediation, but still, when it comes to conclusion, if there is a settlement, that settlement has to be brought back to the courts, and the court is the final authority to accept that settlement, and a compromise decree, a court decree would be issued. Now, this convention has a benefit. The mediated settlement agreement itself is enforceable in the courts because this itself is a piece of document which is accepted to be recognized and enforced. In that way, it is quite a good development from the earlier situation of understanding the mediated settlement agreement. One thing is that the lack of an efficient and harmonized framework or the qualified mediators. I think now there are many institutions like BIMS or many other global institutions which are all facilitating the training for mediators, bringing in people to understand the mediation process. Thereby, the mediators or the people who are going to be trained to be a mediators who are going to be effectively recording those settlement agreement. Anyway, the settlement agreement is going to be drafted by the parties, but ultimately it will be endorsed by the mediator if required. The mediator also might guide or facilitate the parties in deriving this mediated settlement agreement. In that way, all these institutions, along with this convention, are facilitating the drafting of the conclusion of this particular process. Further, this convention obviously addressed the lack of effective means to enforce cross-border commercial mediated settlement agreement. No doubt, many countries cross-border issues they are trying to amicably settle. Once they try to settle, that settlement document or instrument has to be enforced. How to enforce? How to take it forward? And ultimately, if one country is not accepting that settlement due to some internal issues, non-acceptance by their legislature, because any instrument has to be ultimately recognized by the local government, and if the legislature is not accepting in principle, then how to deal with it? How this convention is going to address? No doubt, this particular convention facilitate businesses, particularly the commercial transaction done by these states as well as individuals and corporates. These businesses can have greater assurance that mediation can be relied on to settle cross-border commercial disputes. In that way, it can also be enforced more readily by the courts of contracting parties to the convention. The courts obviously are going to recognize the outcome of that mediation because that particular jurisdiction have signed or ratified the particular convention, that is the Singapore Convention. And in that way, it is also giving an option to defend any such claim. Ultimately, this convention as a benefit will facilitate the growth of international commerce and promote the use of mediation globally. No doubt, we have clear opportunity for developing our economy, developing our trade activities, developing the expertise which is already available to go globally. That is very important. We have mediators. Mediators are already available in Bangladesh. The expertise is already there in that jurisdiction, but still that has to go globally. The expertise, the judiciary having acceptance ratio of that particular concept has to be globally recognized, and for that this convention facilitates. And if we are signatory, or if you are going to ratify, and if you are going to have a law for this mediation, obviously that will make our experts, our mediators, our mediation councils, the mediation advocacy is going to see the Himalayan, try to say, and that Herculean task would be easily defeated, and we people also can get effectively involved in mediation, thereby our expertise, our traditional knowledge, that is very important. Our traditional knowledge of resolving disputes, starting from our family value to the international commerce and trade, what we are doing for long years in the Bay of Bengal, that will be facilitated for other country and other parties coming from different jurisdictions. And if you consider all these in mind, some interesting features of this convention also has to be kept in as a model of principles for us to deal this mediation. A few I'll try to share here. This convention, it will not apply to international settlement agreement concluded in a course of judicial proceedings. It recognizes only settlement agreements which is evolved from mediation process, and it will not apply to any settlement agreements concluded for personal, family, or household purposes by one party, that is consumer. Consumer disputes is not coming under this convention as of now. It might come in future, as well as settlement agreement relating to inheritance, our personal laws and employment laws, that we have to wait and see what the convention is going to deal with. Except this consumer disputes, except this family disputes, family in the sense inheritance alone, inheritance and some employment disputes, and other than settlement arrived from the judicial process, all are considered under this convention. Next, the courts of contracting party will be expected to handle applications either to enforce the settlement which falls within the scope, or to allow a party to invoke the settlement agreement in order to prove that the matter has already been resolved. It is not the court recording that settlement. Please keep in mind, the courts are not recording the settlement. The courts are just enforcing the settlement which is happening much before. The process is happening outside the court much before, and there the mediators are going to facilitate it. Further down the line, like arbitration, this convention also gives option for refusing to accept this settlement agreement. When most of you, I think even in the Bangladesh arbitration legislation, the earlier one, the 1940 as the 2001 also, it is very clear that we have an option to set aside, file an application or appeal against that award, wherein there are some grounds. Similarly, this particular convention also gives certain grounds to challenge. Apart from these, this particular convention and the model law is now facilitating arbitration in a maximum possible chances. And now This convention and the model law is going to facilitate not only court annex mediation, it is going to facilitate agreement based mediation and international mediation. With all these good development and judges, honorable judges like all of you, it is the right time for all of you to effectively utilize this existing piece of legislation, which is the Section 89. And if Bangladesh is going to adopt that particular convention, you are also going to have this mediation law. In India, we are on the verge of having a mediation law, and many of our apex court judgment has also facilitated to go for mediation law. Now we are going to have a mediation act in a year or two, and with that, we can facilitate mediation, and ultimately we can resolve all the disputes within a reasonable time, reasonable cost, and with fullest satisfaction. That is very important. As I am an arbitrator, as you all are honorable judges, all of us would be satisfied when we are going to dispose of a particular dispute, whether one party is going to win or other party is going to lose. We have the satisfaction of accepting the legal principle and delivering the judgment. In the same way, when we are going to facilitate such mediated settlement agreements, the parties who are going to be the stakeholders who have the maximum satisfaction, that is going to be facilitated by us. That is going to be the ultimate objective for all of us when we are going to deal with all these mediation, whatever might be the process. It can be court facilitated, it can be the parties driven, or it can be an agreement based. Whatever might be, all the mediated settlement or the process ultimately ends up in the settlement agreement. And as a society, we are going to facilitate a harmonized, acceptable, and peaceful society. With these few words, I thank you and thank honorable judges and Bangladesh International Mediation Society for giving this opportunity to share some information about this model law as well as the Singapore Convention. Thank you.
Thank you, sir, for your sincere speech and being within time. Now it's time for the question and answer. If there is any question concerning relating to the topics that has been delivered by Mr. V. Raghavan, please put your question. I don't find. Sir, yes, we have His Lordship, Mr. Justice Muhammad Iman Ali, sir, to put the question, please.
Yes, thank you very much for a very illuminating discussion on the Model Law Singapore Convention. I agree with you entirely that we are expanding in our commercial activities and particularly international trade. And for these purposes, we certainly need to be signatories to the convention in order to be able to enforce the agreements that are arrived at. But one question that I have is something that you mentioned towards the end, and that is the exception in the convention, which says that does not apply to settlement agreements that have been approved by a court. Now, if you look at our Section 89A and Section 89 subsection 5, if I'm not mistaken, of that section, which provides that the agreement reached in the mediation is to be produced to the court, and the court will pass a decree. And the decree will be in terms of Order 23 of the Code of Criminal Procedure, and Order 23 Rule 3 of that order says this: where it is proved to the satisfaction of the court that a suit has been adjusted wholly or in part by lawful agreement or compromise, that is the mediation agreement, the court shall order such agreement, compromise, or satisfaction to be recorded and shall pass a decree. Now, if that is the decree arising out of the mediation that has taken place either by the court mediating or by the court appointing a mediator and subsequently the order coming to the court for decree, then is that not excluded by your convention article 1 sub-article 3?
Yes. Yes, sir. You are right, Honorable Judge. It is very clearly given that this particular convention is going to facilitate a separate statute for mediation. What is in existence, that is like Section 89A of CPC of Bangladesh, as well as Section 89 of CPC of the Indian government. In all our mediation, existing mediation, we call this category of mediation to be court annexed mediation. This is not coming under the purview of that future legislation, at least in Indian context. What we are expecting is that that particular legislation is going to give a different mechanism for enforcement of settlement agreement. Here, in this convention, as of now, they're much focusing on that international settlement agreement. I think if the Honorable Judge can accept this concept of 89A dealing with much of the domestic disputes, the pending suits, whatever the parties filed as a civil suit in the courts, pending legislation, the pending suit which the judicial officer or the judge feels that it is there is an element for settlement, it can be referred to all these ADR mechanism. And if it goes to these ADR mechanism, particularly mediation, once that settlement get back to peaceful settlement is arrived in that process, it get back to the court to get the sanctity of enforcement. For that purpose, it is going to a process, getting back to the courts, and the courts are recognizing. Now, we are all dealing, this convention is dealing on the international settlement agreements, which is not within the purview, existing purview of the legislation, what we have for the court annexed mediation. This convention is going to deal with only international settlement agreements as of now. Very clear. For that enforcement, we need to have a separate mechanism, and we can't just bring it under this 89, and it has to be excluded, and it has to be specifically mentioned in a separate legislation. That is my understanding of that particular article given in that convention.
Yes, thank you.
So, sir, as you have said that said about the model laws under the for the international trade law, so you have prescribed about ratification and acceptance of the model law by the Bangladesh government. So, as per the international law and as a matter of obligation, if Bangladesh becomes a signatory and accepts that, Bangladesh will have to lay down a separate legislation exclusively for the commercial disputes springing out of international trades. So under these circumstances, so far my understanding is concerned, or my understanding goes, if I am not mistaken from your lecture, I think that there will be a separate mechanism. There will be a separate law describing a separate modus operandi for dealing with the disputes that are arising out of the international trade. But under that circumstances, had it been so, say for example, within the next 2, 3, or 5 years, so the existing mechanisms, as has been illustrated by our Honorable Justice Iman Ali Sir, as we see, different mechanism of mediation has already been prescribed in different laws. So don't you think that law that is expected to come out within the next 3 years after the ratification or the acceptance will be in a kind of clash or collusion with the other existing mediation mechanisms that are already being prevalent in the other laws?
Yes, sir. As rightly mentioned, highlighted by our Honorable Judge and Mr. Afzal Haq, sorry for wrongly pronouncing your name.
You can call me.
It is very clear that if a new legislation is going to be created on the front of mediation, our expectation is that there might be consolidation of all diversified or allied laws. The provisions of mediations in all the laws might be consolidated. That is one possibility. And another, to avoid contradiction or a different perspective of understanding mediation. To begin with, how we had this arbitration. I think most of you would accept. We had this arbitration act, which act is dealing both international and domestic. I think in Bangladesh also, it's dealing with both the nature of disputes, and there is an
exposure of the issues. And so, respected research persons and ladies and gentlemen, as I have already mentioned in the at the source of this of today's session, Ms. Paksoy and Mr. Ahmed Shohel, sir. And among these assessors, we have these for the participants present here on today's session.
Thank you. Honorable Mr. Justice Muhammad Iman Ali, Honorable Judge of Appellate Division, Supreme Court of Bangladesh, Chief Trainer of this training program, distinguished trainers, participant judges, mediators, and friends from the mediation community. Ladies and gentlemen, a very good afternoon to all of you. In Bangladesh, he empowers